Well, it talks about the social right in Article 7. Jane's spoken about 4.5 million. Mr. Ainsworth, who was one of the lead claimant in the string litigation, went to the AT, the Court of Appeal, the House of Lords, the ECJ, and back to the House of Lords, and eventually succeeded in his claim for £16 and 14 pence. But anyway, it's not the big claims that generate the difficult points. Now, I'm going to talk mainly about Article 7. I'm well aware that there are people in this room who are working time specialists and others who aren't. So there is an extremely detailed handout with, and I hope what you find is a beautiful font. So if you want to discuss it with me afterwards, try and catch me before I go. But anyway, Article 7 is all terribly simple. Every worker is entitled to paid annual leave of at least 4 weeks. Conditions to be laid down by the national legislation. The minimum period of paid leave may not be replaced by an allowance in lieu except when the employment relation is terminated. All very simple and implemented by the working time regulations. Now, firstly, just the background to this. 7 Court of Justice decisions on how the right applies to workers off sick, a remarkable number, allowing you to show off your expertise in Spanish, German and French, sneer at those who mispronounce the names. Though they in turn generated a variety of domestic decisions, often inconsistent, but now we're lucky enough to have current last word on the subject, NHS Leeds and Lana, Court of Appeal, where I appeared. But Mr. Justice Mummery, no doubt, sick of hearing working time cases and looking forward to his retirement, gives us that little message there that it's still not in a completed state. So we look forward to further litigation in the future. But it's probably more certain now than it's ever been. I'm just going to go through the basics. Apologies to those of you for whom this is sucking eggs. Primary duty is interpretation. And a national court must interpret national law implementing a directive so far as is possible to comply with the result that the directive seeks to achieve. Now, and the best authority for that is Coleman number 2, where Mr. Justice Underhill rather conveniently summarises all the more difficult authorities and tells you what they all mean. And you'll remember in that case he read words into the DDA in order to ensure it covered associative discrimination. We see exactly the same. The only limitation on that approach is the interpretation must not cut against a fundamental feature of the legislation or various other metaphors used by the House of Lords in Gaydon. In practice, it will nearly always be possible to interpret the working time regulations in order to comply with the directive and the decisions on the directive. And exemplifying that is Lana itself, because we'll see in Lana the court was quite prepared to add words to Regulation 13.9 to permit carryover, and it was also prepared to add a whole subparagraph to Reg 14 to allow payments in lieu on termination. So in broad terms, you can always achieve the result by interpretation. Doesn't matter whether the respondent is a state body or a private employer, you can get the end that's required. But we now have another case rubbing further salt into the respondent's wounds, that Article 7 is now directly effective against a state body. Those of you who remember Foster will know that the conception of state in ECJ terms is a very wide one. It extends to NHS bodies, police authorities, local authorities, perhaps not some privatised utilities, but nevertheless a very wide conception. So the key message is in practice it's all going to be about interpretation. So there's 2 real issues. What do the principles of the Court of Justice decisions mean? Unfortunately, some of these decisions have been misinterpreted in the past. There was a decision in the Bristol region called Kahn and McColl, which reached some rather alarming conclusions about what the European jurisprudence meant. and said, without referring to various ECJ cases, what they were supposed to mean. And there were others, those of you who are in this area will know, there are other inconsistent tribunal decisions up and down the country. What's the most difficult issue probably is how you apply these decisions practically. And what I've sought to do at the end of this talk is to give 7 practical illustrations of how I think the principles feed into actual factual circumstances. Of course, they're my views. You treat them with the usual caution, and if anyone ends up having to pay compensation as a result, I don't want to know. The background to the directive, introduced initially, I'll just quickly skate through the background to the directive and the working time regs. Introduced as a health and safety measure under former Article 118A. The government got very upset about that. You'll remember its Viry's challenge lost in UK Council against, UK government against the EU Council. The ECJ saying health means a complete state of social and mental well-being and a complete absence of infirmity. It gives effect to numerous international human rights instruments, including the UN Declaration of Human Rights of 1948 and the European Social Charter and various others. But the one that's most important for these purposes is the ILO Convention number 132 on holidays with pay. Because in this area, it's referred to in the recitals to the directive, it's been repeatedly referred to by the Court of Justice in analysing what the right under Article 7 means. And in particular, you can see Article 6.2 of the ILO Convention, which in many ways offers the key to this whole area. It unlocks a lot of the difficulty the domestic courts have got into. Periods of incapacity for work resulting from sickness or injury may not be counted as part of the minimum annual holiday with pay. Now, it doesn't quite capture the principles, but it gives you the basic key to them. In other words, sick leave is different from annual leave, and sick leave may not count towards annual leave. Quickly to skate over the basic provisions of WTR, and again, apologies to those of you who read these every day. No automatic contractual right to holiday, even, or pay on termination. See Morley and Heritage. The basic 4-week entitlement giving effect to Article 7 in Regulation 13. And then these critical words in Regulation 13.9, which generated a lot of the difficulty with sick workers. Leave may only be taken in the leave year in respect of which it's due and may not be replaced by a payment in lieu except on termination. The payment, as we know, is based upon the calculation of a week's pay as for other statutory rights such as redundancy, the basic award in unfair dismissal, without a statutory cap. But that whole statutory scheme may need to be rewritten in the light of the Williams and British Airways case, which Jane and I have recently done in the Supreme Court. But that's for another day, because it's a whole topic of its own. The one that causes the most problems in terms of sick workers is probably the additional leave. Now, this was introduced in 2007, partly to give compensation for those workers who didn't get banks holidays. Rather unfortunately, as a result of CBI lobbying, we now have this right arising in 2 different ways, with a retrospective test to determine which one it arises under. The first one is it can arise under a contract. That is, and this is the nasty bit, if a relevant agreement, as at the 1st of October 2007, gives each worker in the workforce, that is, 1.6 weeks leave. In other words, to decide if the worker's right to additional leave doesn't arise under Reg 13A, but arises in contract, a tribunal now, in 2012, has to analyse what were the contractual rights of every worker in the workforce as at 2007. A more stupid piece of drafting would be hard to imagine, but there it is. If every worker in the workforce wasn't given that additional leave by virtue of contract as at 1st of October 2007, then the right arises by statute. Adding to the complexity, here carryover is permissible, but only into the immediately following leave year and if a relevant agreement so provides. All right? So that's all very straightforward. Now we come to what the Court of Justice made of all this. Now, the first case that gave any hint about workers on leave for one reason might be able to take their annual leave at another time was Marino Gomez. You probably remember that case. Spanish woman who's on maternity leave. She comes back after maternity leave. The period of annual leave coincided with the period when she was on maternity leave, and the ECJ says she can take her annual leave at another time. But it wasn't clear how that applied to workers off sick, because, of course, maternity leave is a guaranteed, European guaranteed right via the Pregnant Workers Directive. So we eventually come on to the Schultz-Holf and Stringer cases. Stringer involved two categories of worker in broad terms. First of all, there was Mrs. Khan, who'd asked the Revenue to go on leave while she was on sick leave, and they said, no, you can't. She obviously was hoping to get her full week's pay. The other lot were all claimants who had been off sick for the whole leave year prior to termination, and then had been paid Regulation 14 payments, and the Revenue challenged them. They claim they selected cases at random, but I noticed that every single one involved a claimant who hadn't worked for many years. In fact, one of them had tupied across them and never worked for them. So I suspect they were deliberately selecting the worst test cases. Anyway, the Court of Appeal, very unhappy about this, said you can't take leave unless you are an obligation to work. Unless you actually are working, you're not getting leave from anything. Just before the House of Lords was about to start, we learned of another case from Germany that had been referred to Europe, Mr. Schultz-Holf. He also was off sick for a long time, and under German law, he wasn't allowed to take any leave. So, but under German law, he could carry over leave into the following leave year, but only for 6 months. So, we get to the ECJ, completely different starting point. It doesn't start with what leave means. It says, don't be silly, these people are still workers. Whether they're sick or not, they're entitled to leave. And then it lays down the two fundamental principles. First of all, a member state may provide a worker cannot take annual leave, but this is the sting, provided that the worker in question has the opportunity to exercise that right during another period, i.e. during a period when not sick. Mr. Schultz-Holf was off sick throughout. He never returned to work. He never had the opportunity to exercise his right. Therefore, there'd been a breach of his right under Article 7. Or a member state, and this is where it does differ from the ILO Convention, may allow a worker to take paid annual leave during sick leave. But that's if the worker chooses to do so. All right? So there's your two key principles. And finally, the payment on termination must compensate for the leave that the worker is unable to take during sickness at the rate of normal remuneration. In other words, translating that into the claimants, the Regulation 14 claimants were entitled to full compensation for the leave they'd been unable to take, just as if they were at work and didn't take their leave, and Mrs. Khan was entitled to compensation for the leave she applied to take while off sick. Aha, many people thought, but what about, these are just people who are told they can't take leave. What about those who don't want to? And that arose in Pareda. Mr. Pareda's off sick during his period of allocated leave. The employer refuses his request for leave during a different later period. And now the European Court of Justice, again having regard to the ILO Convention, goes further. I've not forwarded on your slides. The second bullet, a worker who does not wish to take annual leave during sick leave has the right on his request to take leave when it does not coincide with sick leave. In other words, if a worker doesn't want to take sick leave while he or she is on annual leave, she doesn't have to, and they can take it at another time. Now, many commentators got very excited at the fact that the Court of Justice referred to a request, saying the worker on his request can take leave at another time. But that's obviously only in the context of someone who's come back from sick leave and then they can only take annual leave if they request it. So the need for a request arises in Pareda, because how else can you ever decide if that worker wants to take leave during another time, unless they request it. Case 4, Schulte. He's off sick for a very long time, 6 years. And in his case, leave untaken due to illness was lost under German law 15 months after the end of the leave year. For those of you who really are keen on the detail of this area, the IRLR head note is wrong. He was only applying to carry over his 2006 leave into the following his termination of employment in 2008, which was more than 15 months after his employment terminated. The Court of Justice by this stage does start to place limits on the amount of carryover. It says, look, if you're just going to carry over leave forever, effectively by the time you come back to work, after 6 years, you're entitled to take 6 fours, or 24 weeks off. You then come off and take 6 months holiday. So they place a limit on it. But the critical principle is that the period must be substantially longer than the reference period. In other words, the reference period being 1 year, it must be substantially longer than that. But 15 months was permissible. It had regard again to the ILO Convention that talks of leave being taken within 1 year or 18 months after the end of the leave year, and said, looking at that, we think 15 months is okay. I think, incidentally, 15 months is probably about the minimum, because after all, if it's got to be substantially longer than the 1 year reference period, it seems hard it can be much less than 15 months, but there we are. Next case, Dominguez. I'll be very quick on this. Can't quite see how it got there at all, because Mrs. Dominguez was off sick after a car crash on the way to work. She wasn't actually entitled to count that for her annual leave for the purpose of taking annual leave. The Court of Justice said, don't be silly. She's a worker if she's off sick for any reason. The main point of interest for it is, firstly, that the court there said this right is directly effective. In other words, you don't even need implementing legislation. And secondly, they said, and this was the bit that's picked up in the next case, a member state could have different rules for any leave in excess of the basic 4-week entitlement guaranteed by Article 7. And that was picked up in Neidl, the next German case, where Mr. Neidl, off sick from June until his retirement in June 2007 until his retirement in August 2009, never made a request to take or carry over leave, took no leave, entitled to 30 days, but there was a carryover period there of 9 months after the end of the leave year. So by now you're getting used to the answers here. He was entitled to a payment on termination, undiscounted, because of his untaken leave. A carryover period of 9 months was too short, because remember, it has to be substantially longer than the reference period. So he could carry over leave from 2007 into 2008 and 2008 into 2009. But national law could provide for forfeiture following sickness of the additional period of leave. That is, any period over and above the 4 weeks. That is because Article 7 only lays down rules in relation to 4 weeks. So member states can lay down different rules for the basic entitlement than they lay down for the additional element. Last case, and the one that's going to upset everyone, even employers even more, and Jed, I'm not sure how you pronounce that in Spanish. Here we get faced with an extension of Pareda. In Pareda, he actually went off sick during a period when annual leave was already scheduled. In Anhed, I think it is, the person, there was a challenge to whether workers who simply fell sick during annual leave could take the period of sickness, take that annual leave at a different time, and the Court of Justice says it's irrelevant when the incapacity for work arose. So if you go away on holiday, have a very nasty accident at some stage, wake up with a headache, that sort of thing, and you're temporarily incapacitated from work, you must be allowed to take your annual leave at another time. Again, echoing the ILO Convention. Right, so that's the easy bit. So now I'm quickly going to give some practical examples of how I think these principles apply. The basic structure in each case is think, first of all, what does Article 7 require? Secondly, how does that apply to the basic leave in Regulation 13, the 4 weeks? Thirdly, what do you do about the additional leave? Note of caution, beware of authorities before LANA. Don't rely on them. So, easiest one, number one, a worker on sick leave asks to take holiday during her sick leave. What's the answer? Answer is she must be allowed to take it. National law can allow that worker to take 4 weeks leave. See worker. There's no problem on interpretation. The worker is a worker, whether sick or not, though presumably they must serve the Regulation 15 notice. What happens about the additional 1.6 weeks leave? Well, in theory, you could have different... the apostrophe is in the wrong place. In theory, you could have different rules. As a matter of contract, it depends. If the right arises in contract, it depends what the contract says. Can someone on sick leave take annual? Can someone who's sick take contractual leave? That depends on the terms of the individual contract. If the additional leave arises by statute, i.e. by Reg 13A, in theory, there could be a very nice, ingenious argument that all the principles of Stringer don't apply. In practice, I think that's very unlikely because a worker's still a worker. If they can take their Reg 13 leave, it seems very odd to say worker means something different in Reg 13 and Reg 13A. But I look forward to some clever person trying that argument out. Next one, again easy. Worker falls sick before or during their annual leave. Answer to the first point, easy. They must be allowed to take their basic 4-week entitlement another time. So they come back and say, very ill for 2 weeks of that holiday. So I'd like my 2 weeks of annual leave again. They just serve a Reg 15 notice. If it's refused, they go to the tribunal. They point to Anjed, say, look, I'm a worker, and they win, I think. What about the additional period of leave? Again, Reg 26A all depends on what the contract says. Reg 13A, I think the probable conclusion is that they're not allowed to take it because it would be said, look, these are all very special rules informing how Regulation 13 operates. They shouldn't be read into Reg 13A. But obviously the opposite is arguable, and we're going to face difficult issues. For example, what sort of evidence does one look at to see if a worker was ill on holiday? And if a worker is sick, are they using up their Reg 13 or their Reg 13A leave? But fortunately, time is short, so we have to skip over that. Number 3, here we have a worker off sick for all of one leave year. They take no leave, they come back in the following leave year, and then they say, I want to take my untaken leave from the previous leave year. They all become very simple when you've spent about 2 years thinking about them. The answer is she does have the right to take her annual leave on return because she couldn't take her leave in the first leave year because she was sick. So she must be in accordance with Stringer, Pareda, Schulte, allowed to carry it over for at least substantially longer than a year, i.e. into the next leave year. The only bar in WTR is Reg 13.9, which says leave must be taken in the leave year in respect of which it's due. But see Lana, where the Court of Appeal was quite prepared to read words into Reg 13.9 as you see them there. In other words, carryover was permissible where the worker was unable or unwilling to take leave because he was on sick leave, and as a consequence, he could not exercise his right to take annual leave. The carryover of the additional period in those circumstances depends upon what the relevant agreement says or the contract says, because it can be carried over into the immediate following leave year, so you need to look at that. Lovely. Number 4. Actually, I'm beginning to lose track of what all these mean now. Worker off sick for all or part of the leave year in which employment terminated, and then their employment is terminated. Again, relatively easy for the worker as regards the Reg 13 calculation, because they're in exactly the position of the stringer claimants. They've been off, they've been off sick that whole leave year. You simply apply Regulation 14, ignoring completely sickness absence, just as the revenue conceded in stringer when we got back to the House of Lords, and that was why Mr. Ainsworth got his £16.14. That was his undiscounted Regulation 14 payment. What do you do about the additional period of leave? Well, I think it's probably very artificial to apply a different Regulation 14 calculation to the Reg 13A leave. Again, a point to be discussed afterwards over several glasses of wine, but I think it would be artificial to do so. The reg, if it arises in contract, then it all depends upon what the contract says as to how the payment on calculation is terminated. Number 5, worker off sick for the whole of the preceding leave year, takes no leave, and then dismissed in the following leave year while still off sick. Got it? So this is with a carryover and then termination and never coming back to work. The basic 4-week entitlement, very simple. It carries over from the preceding leave into the following leave year. It must do, because the carryover must be longer than a year, so it can obviously go from leave year 1 to leave year 2. Reg 14, this is the point where the Court of Appeal shows the breadth of the interpretive obligation, can be interpreted to give a payment in lieu. And those are the words the Court of Appeal read into Reg 14. Note critically, that means there is no pro rata discount to the carried over annual leave. In other words, if the worker didn't take the 4 weeks, they carry over and termination takes place halfway through the leave year, those carried over weeks aren't discounted by 50%. They get the full 4 weeks. And that's consistent with the ECJ jurisprudence. And these broadly are the facts of Lana. All right? So they get the full 4 weeks for the previous leave year plus their Reg 14 payment for this leave year. A lot of money. But what about what happens to the additional period of leave? Again, it all depends upon what the relevant agreement says. Okay? If it does permit carryover, then it forms part of the entitlement, and therefore it's part of the Reg 14 calculation. We're nearly at the end. Now, 2 nasty examples to end on, just to the point where everyone can no longer think straight. Anyway, worker off sick for most of leave year 1, not all of it. Say he or she takes 3 weeks leave, so 1 week not taken, returns to work, and then dismissed during leave year 2. What happens to that 1 week's leave? Now, I think the critical question here is a question of fact. If that 1 week's leave carries over, then it's part of the entitlement in the second leave year, and therefore they should get compensation for loss of it. But the critical question is, and look at the Court of Appeal's interpretation in Reg 13.9, was it as a consequence of sickness that the worker was unable to take that 1 week's leave? And I think that's going to be a factual investigation in each case. The worker may say, I expected to take my leave later in the year, I didn't realise I would fall sick. That's going to be the question. If the worker couldn't take it because of sickness, as a matter of fact, then the Reg 14 payment must reflect carried over leave. If it wasn't because of sickness, they couldn't take it, they just didn't take it, then they lose it, just like any other worker who doesn't take leave and who, in the leave year, who loses it at the end of the leave year. And that may be how you can justify the decision in Fraser that I know is referred to in the Court of Appeal, and some people have said, well, in Lana, and some people have said, well, is Fraser right or is Fraser wrong? The facts of Fraser are summarised there, but the critical point to note is that Mrs. Fraser was certified fit to work from November 2007. although she didn't, for reasons which are too dull to go into, didn't return to work. But she wasn't actually dismissed until October 2008. So she did actually have a considerable period to take leave that had carried over from previous leave years. And it may be in those circumstances one can say in facts like that, she had the opportunity to take leave. It wasn't sickness or unwillingness to take leave year during sickness that stopped her taking her leave. Finally, I can see Mark getting very twitchy now. The nastiest one of all, what about the worker who's off sick for several years? How many years of leave carry forward for the purpose of taking leave or the Reg 14 payment? Same issue, effectively. How many leave years carry forward? There's no problem here with the additional period, because you'll remember, whether it's by contract or by Reg 13A, leave can only carry forward into the immediately following leave year. And you remember, NIDL, member state may lay down different rules to the additional entitlement over and above the 4 weeks. So the additional entitlement can only carry forward if a relevant agreement says so, and only into the immediate following leave year. The problem is, what about the 4-week entitlement, the basic one? Because remember, the carryover period, first of all, must be substantially longer than the 1-year reference period, shorter, where the European Court said 15 months is permissible. Now, the critical issue is this. The two competing arguments there, very inadequately summarised, are first, all the court said in shorter was, it is permissible in national legislation or practice referring to the practice by which collective agreements in European countries have the force of law, permissible for national legislation or practice to lay down a carryover period provided it's substantially longer than 1 year. So therefore the 15 months in shorter was justified. The argument for the claimants is very much that. In other words, you need national legislation or practice. In the absence of national legislation or practice, and there's no national practice in the UK as far as I can see, carryover is forever. And until the government passes legislation saying there's a 15-month period, every bit of leave carries over. So someone who's been off sick for 9 years comes back, doesn't come back, their employment's terminated, they get 36 weeks holiday pay. The alternative argument, and the one that Sean Jones floated in Lana but no one dealt with, was that you must read in a time limit by virtue of Article 7 itself. In other words, the need for a temporal restriction flows from Article 7 itself, and that, therefore, some form of temporal restriction must be read into the working time regulations. Not sure quite how you do that, not sure how you'd fix the period, which would have to be done, because it seems to me that is a matter for national legislation. But that's effectively where we are, and that's the case that still remains to be decided. Does the worker off for 9 years get 36 weeks pay, or do they simply carry over presumably 2 years? I don't know. It's got to be, I think, at least 15 months. How long? Anyway, as Lord Justice Mummery said, we never get closure in these things. Thank you.
Mike, thank you very much.